complaints, of which 24,000 were finalized. And this is a team effort with all the employees of Public Protector South Africa. And we finalized more than 60 investigation reports. We remain focused on the Vision 2023, which has 8 pillars of enhancing access to our services, engaging communities in their mother tongue, increasing our footprint, leveraging stakeholder relations through MOUs, projecting an image of being a stronghold for the poor, ensuring that the communities are well versed with their rights, and we encourage state institutions to establish in-house complaints resolution measures or even sector-specific ombudsmen, inspiring people to be their own liberators. One of the areas that we have worked hard to improve over the last 2 years is providing a better service to the public. To this end as well, today we are launching the Public Protector rules. The rules are more like regulations, similar to court rules. They govern how matters entrusted to my office are handled and processed. They seek to expedite the resolution of complaints by facilitating cooperation with investigations and implementation of our remedial action through the standardization of things such as timelines, subpoenas, search and seizures, alternative dispute resolution mechanisms, contempt of the public protector, and related fines. The rules are also outline procedures of lodging complaints, procedures for resolution of disputes, service standards applicable to the public protector staff in relation to investigation and resolving disputes, timeframes for organs of states to respond to our findings. They go into finer details such as who can report a matter or lodge a complaint with the public protector, the manner of doing so, and the information required to that effect. So the public protector rules outline the format and procedure of our investigations and the responsibilities of state institutions and the public protector staff, and also including alternative dispute resolution mechanisms. They were crafted and published in terms of Section 7 of the Public Protector Act, and they are now gazetted. So they are also available in the Public Protector website. You can go through for yourselves to familiarize yourselves with our rules. Now I turn to the main focus of the briefing, which is to reveal to the public the outcomes of numerous investigations that I've been working with and the team. And I must indicate that a lot of these investigations relate to years dating back to 2013, are still part of our backlog reports. In total, there are 13, and they relate to poor administration, abuse of power, abuse of state resources, and the plight of whistleblowers. So I'll start with the systemic investigation which was conducted, and we will term it an advisory report. This report is not issued in terms of Section 182 of the Constitution, but is an advisory report to the Minister of Health, which was issued, and it details the observations which the institution made with the investigation conducted or the dialogues and stakeholder engagement in 2018. This therefore is not an investigation, but then this report is utilized by the department to improve on service delivery. The first one relates to public health sector. The public protector visited all 9 provinces and paid surprise visits to at least one health facility in every province. After that, the public protector engaged with both members of the public and officials working at those health sector facilities. At all times, the public protector was accompanied by officials from the National Department of Health. So this was in 2013. The focus of the visits relating, or the complaints which were, or issues which were raised related to cleanliness, infrastructure, lack of equipment, peripherals, and overcrowding in wards. They also raised issues relating to quality of service, such as long queues to consult, access to medication, shortage of medication, delays relating to ambulances, staff shortages, especially healthcare professionals. So during the surprise visits, members of the public and officials at healthcare facilities raised also various other complaints, such as inadequate infrastructure, as I've indicated. So in relation to this, an advisory report was then sent to the Minister of Health, where we were advising that they should consider putting together a comprehensive and holistic strategy to deal with the observations in this report and the findings of the National Healthcare Facilities Baseline Audit. And further, the department should consider strengthening the Office of the Health Standards, in particular as it relates to its independence and the enforceability of its remedies through legislative amendments. The department to consider the feasibility of sourcing a comprehensive healthcare management system that will address electronic filing, tracking patient medical history, and queue management. The one relating to the RDP housing program is the second advisory report. In this one, also, this was conducted around 2011, 2013. As I said, it's part of the systemic investigations, which was a backlog, one of the backlog investigations in this office. So that report as well was finalized and has been sent to the Minister of Human Settlements. It relates to the planning and administrative processes involved in the delivery of RDP houses. And what we did was to consider issues relating to procurement or in allegations relating to state, failure of state to pay benefits due to the RDP housing projects to commence, and issues relating to contractors where there's delay also to finish the houses which were built. Allocation of RDP houses, the issue was raised under this heading related to unintended beneficiaries, allegations of removal or changing names of beneficiaries who were on the list, and complaints relating to undue delays to allocate the houses to the beneficiaries. So all this was done in all the 9 provinces. There were also problems relating to post-allocation problems, delays in issuing of title deeds, and what we recommended to the Minister of Human Settlements was as follows. As far as planning is concerned, the state should consider establishing a compliance monitoring divisions to ensure that the required processes are complied with before implementation of the RDP projects. So in this instance, there was clear lack of planning. On procurement, the aforementioned compliance monitoring divisions should also be tasked with monitoring compliance with prescripts in the procurement of RDP houses. Allocation, so the government should consider putting in place plans with clear time frames to prioritize adjudication of RDP houses. And post-allocation, the state should, through happy letters, advise beneficiaries on the process to be followed where structural defects are discovered after handing over the RDP houses. And on title deeds, we said the state should develop and adopt a strategy with clear time frames on how to eradicate the existing backlog in the issuing of title deeds. I must indicate that as the public protector, we also assisted the Department of Health and Human Settlements to establish ombudsman offices where then people can complain to those institutions directly. That is assisting the public protector to then focus on other complaints. And we also have an MOU with the Health Ombudsman, and we're working on one with the Human Settlements Ombudsman. I must indicate, though, that we still receive complaints relating to RDP-related complaints and health-related complaints, though we work closely with those two ombudsman offices. So the reports which are issued in terms of the Constitution, Section 182, subsection 5, are as follows. The Kamanyane report, I investigated allegations of failure by Dr. Ruth Sokhomotsi, Mompati District Municipality, formerly known as Bopirima District Municipality in the Northwest, to submit the names of 26 former employees of the municipality to the Cape Joint Retirement Fund for purposes of receiving additional benefits subsequent to their transfer to the Provincial Department of Public Works and Roads in July 2001. So this complaint was received in 2015 from these 26 affected complainants. They allege that they suffered prejudice as a result or the conduct of the municipality. Having considered the evidence which we then uncovered that during the preliminary investigation, I have decided to resolve the matter through mediation and conciliation, and we signed a settlement agreement which was facilitated between my office and the complainants, which was also signed with the municipality. So in terms of the agreement, the municipal manager is to effect payment to all 26 complainants in accordance with clause 2.1 of the settlement agreement signed between Dr. Ruth Sokhomotsi Municipality and the complainants on 26th of August 2018. And further, the municipal manager, within 30 days of publication of this report, should identify all the other affected employees, because there might be more other employees, and as well compensate them. And further, the municipal manager must within 15 days determine the benefits payable to all employees or former employees, pays 60% of each member's gross benefits from the Cape Joint Consolidated Retirement Fund, plus the 15.5 interest therein. The second report relates to DHEMO, which I investigated. It also relates to the Northwest Provincial Department of Public Works and Roads to transfer the house to her, which she procured. This relates to a 71-year-old pensioner who lodged a complaint in 2012. So it's also part of the cases which we've delayed to finalize. So she alleged that she approached the department in 2008 and offered to purchase the property. She paid an amount of 112,000, and after paying that amount, she further was requested to pay 3,400 as transfer costs to the state attorney. In 2009, she was advised to pay again an additional occupational rent per month until the property is registered into her name. So she was not allowed to alter or extend the property until it was transferred into her name. To date, the department has allegedly failed to transfer the said property into her name. This was resolved by the office, where we then had a finding that the department failed to register and transfer ownership of the property into the complainant's name. And the following were the findings: that the head of department must, within 30 days from date of publication of this report, provide the Office of the State Attorney with all the necessary documents to enable State Attorney to register and transfer ownership of the house into the complainant's name. That the State Attorney must, upon receipt of those documents, register the property into her name, and further that the head of department must refund the complainant all those 200 rents which she was paying since 2009, and must stop charging the occupational rent accordingly, and the HOD must within 30 days from date of publication of this report send an apology letter to the complainant for the undue delay of the transfer of ownership. So the next report relates to Mr. Chester Staples. This is an investigation relating to the failure by the Northwest Provincial Department again of Local Government and Human Settlements through its Northwest Development Tribunal process, where an application was lodged by the complainant for the establishment of a development area at a farm near Rustenburg in the Northwest Province. The complaint was lodged in 2013 by Mr. Chester Staples, where he alleged that he is a property developer, and in 2009 he approached a town planner around Northwest to submit an application on his behalf seeking permission to establish a development area on portion 31 and the remaining extent of portion 3 in this farm. So the project was to be known as Chesterton Equestrian Estate. The application was submitted in 2009, and the tribunal preliminary hearing conference to process the application was supposed to take place in 2010. The matter was postponed further, and until 2011 the hearing finally didn't take place. This matter was due to failure by the department to finalize the process to nominate and recommend to the Premier the appointment of the new tribunal members after the first tribunal's term of office had elapsed. So the consequence was that the complainant lost an amount of about 1.3 million, which included fees to the town planners who submitted the application on his behalf. And I found the allegation that the department, through its tribunal, failed to process the complainant's application for the development of a property to be substantiated. I found that the complainant was prejudiced by the conduct of the department. As a result, I directed the HOD that must, within 30 days of the publication, issue a letter of apology, and further the HOD must pay the complainant an amount of 1.3 million plus interest calculated from the date on which the application was lodged. And the HOD should then institute civil proceedings against any official or officials who were responsible for such delay. The next report relates to Mr. Komu. This is also relating to the undue delay to pay for services rendered and maladministration by the Northwest Provincial Government relating to improper termination of a contract with RR Travel JP Tsepi Investment. This followed a complaint by Mr. Komu on behalf and in his capacity as the director of this company. Again, this complaint dates back to 2015. So Mr. Komu alleged that in 2013 the company was awarded a transversal contract for a period of 2 years dating back to 2014 and was expiring in 2016 for the provision of specialized travel and hotel accommodation services to the Northwest Provincial Government. So the aforementioned service included advising the provincial government on the best possible traveling arrangements, destinations, accommodation routes, and etc. So the parties entered into a contract and they signed an LSLA. As early as 2014, he began experiencing problems with receiving payments from the department, and he raised a complaint with the department to no assistance. And in addition, the department allegedly improperly terminated the contract, and they owed him an amount of around 10 million for services rendered between April 2014 and August 2016. So the Northwest Provincial Government also owes him interest that had accrued as a result of late payments. I found that the allegation by the Northwest Provincial Government to pay, or the delay to pay the company, was substantiated, and further that the allegation that the Northwest improperly terminated the contract was unsubstantiated. Based on my finding that the Northwest duly delayed to pay the company, there is a prima facie evidence that indeed there may be some interest which is due and payable to the company on those invoices which were not paid on time. And I found that the allegation that the complainant was prejudiced by this due to the delay was substantiated. So the remedy was that the department should also issue an apology to the complainant, and the Director General should issue this, after issuance of this report, appoint an audit company to audit all the invoices and supporting documents to independently determine the interest payable to the company. And I must indicate that we've resolved through the alternative dispute resolution during the investigation, where the government or the department agreed to pay the 10 million which was owed to the complainant. So now the remaining part is the issue of the interest. The next investigation relates to the South African Local Authority Pension Fund. And this complaint is failure, it's allegations of failure by the South African Police Service to timeously submit disability claims in accordance with the rules of the South African Local Authorities Pension Fund, which is called SALA Pension Fund, thus financially prejudicing the complainants. My office received complaints from 7 complainants, all employees of SAPS and members of the SALA Pension Fund. The complainants allege that SAPS failed to submit disability and death claims to SALA in terms of the SALA Pension Fund master policy. The late submission resulted in claims being repudiated by SALA Pension Fund. As a result of the late submission of claims and subsequent repudiation, the members of the SALA Pension Fund suffered financial prejudice, and in that they did not receive compensation they are entitled to in terms of the master policy. In this matter as well, I must indicate that during the investigation, we also had an alternative dispute resolution where SAPS agreed to pay the affected complainants. And the findings in this report was that the National Commissioner of Police needed to issue a letter of apology to the complainants, and also SAPS should pay the following amounts to the affected complainants. There was the first complainant, Mr. Sijake, it was nearly R1 million. The second one, Mr. Makaba, it was around 600,000. The third one, Mr. Lomo, it was around 1.3. And the fourth one, Mr. Mashiko, around 1.4 million. And the fifth one, Mr. Nyokong, an amount of 1.7 million. And the sixth one, say, Teko, just over R1 million. And then pay interest at the prescribed rate of interest prescribed in terms of the prescribed rate of interest act to the complainants on this amount from date of this report. I must indicate that this matter was also raised in the Free State by one of the journalists, Tuso, who was also receiving a lot of complaints from widows of the members of SAPS. So some of them will also benefit from this particular report. So the Minister of Police was ordered to make sure that all employees are compensated and that there's standard operating procedures for handling such disabilities. There's no more delay by SAPS to submit the claims to SALA so that the payments are paid on time. The next report relates to the Northwest Housing Corporation and the City of Tshwane. It's an allegation of maladministration again by Northwest Housing Corporation this time, and the City of Tshwane Metropolitan municipality regarding the improprieties relating to the sales and transfer of properties that belong to the Northwest Housing Corporation, falling within the municipal boundaries of the city of Tshwane. This complaint was lodged during 2011-2013 respectively by all the complainants. The allegation that the city and the corporation improperly failed to assist the complainants to register and transfer the stands into their names, where the stands were around Ga-Rankuwa, Mabopane, in fact 3 of them around Ga-Rankuwa and 1 in Mabopane respectively. That complaint, my finding was that it was substantiated. I directed the Gauteng MEC for Human Settlements to take cognizance of the report, and within 60 days from issue of this report, appoint an audit firm to investigate if there are any other persons who have been deprived of their property, and within 30 days of the finalization of that process, to make sure that the remedial action is implemented. The next finding was that include in his oversight role with the housing and human settlements activities, the monitoring of implementation of the remedial action taken. I directed the executive mayor of the city of Tshwane within 90 days from the date of the issuing of this report to provide alternative houses, having all the necessary basic services such as water, electricity, sewage system to all the beneficiaries who were dispossessed of their housing rights through the alleged fraudulent and unlawful transfer of their properties, or compensate the complainants with the current market value of the properties that were fraudulently transferred. And within 90 days from, in fact, of the report from the MEC for Gauteng, ensure that the city provides alternative housing, because the MEC will have to conduct that audit, and then if there are additional names, those names should also be compensated. And the city of Tshwane should ensure that within 90 days from the date of issuance of this report, establish a township at the area where stand number 2827 zone 2 Ga-Rankuwa is situated, and register and transfer the relevant property to one Mr. Miel. And show further that they implement the investigation report and further issue an apology to the deprived complainants. Also, this matter, I requested that they should report this to the police, especially where the officials who were involved within the city of Tshwane and the Northwest Corporation, Housing Corporation, to be reported to the police, so that an issue of or the crime or fraudulent crime can be investigated. The collapse of governance at Pikitup. This is another report. I investigated allegations of maladministration and violation of the waste management service provider to the city of Johannesburg, Pikitup's supply chain management processes and procedures in connection with the awarding and subsequent extension of the contract to Aqua Transport and Plant Hire. The investigation also covered alleged irregular procurement of office space to relocate Pikitup head office, appointment of consultants, appointment and removal and replacement of employees in violation of the Pikitup recruitment and selection policies, and payroll and misconduct arising from theft of Pikitup cellular telephones. This probe was prompted by complaints received from Philip Richardson in August 2013 and the South African Municipal Workers Union in 2016. So Mr. Richardson alleged that the contract was awarded to Aqua by Pikitup, was observed as being under investigation, and yet was progressing normally with payments being made to the service providers. Since public funds were invoked, it appeared to Mr. Richardson that both Pikitup and Aqua considered themselves totally above the construct of due process, and they believe that they can act with impunity. And there were media reports relating to this matter, when Mr. Richardson raised the complaint. Some also, on the other hand, alleged that in their complaint that Ms. Ne extended the contract of Aqua and added 40 million despite a decision by the previous board not to extend it. That she irregularly appointed friends and former colleagues without subjecting them to an interview process, and improperly offered them higher salary scales than the normal remuneration scales as prescribed by the Pikitup remuneration policy. The union further alleged that the friends and former colleagues appointed improperly and offered higher salaries. Scales were Mr. Nganana, Ms. Pumla Mukele, Mr. Ngwenya, Ms. Docrat, Ms. Alexander, Mr. Sampson, Mr. Boysen, Mr. Dennison, and Ms. David. It was further alleged that Mr. Ngwenya, who is the son of Ms. Nie's domestic worker, resided at her house, came in with a group of interns and was the only one appointed permanently without following the proper recruitment process. The interns at Pikitup were compensated approximately at 2,000 rands per month, but Mr. Ngwenya was paid around 9,500 per month. Some also alleged that Mr. Boysens was recommended to Pikitup by a former general manager, Fleet, without an interview, and was appointed as the acting general manager, Fleet. Other allegations made by Samu were that there were salary discrepancies among employees of Pikitup, as well as officials related to Ms. Ne were remunerated on a higher salary scale. So in demonstrating these discrepancies, Samu alleged that Mr. Simpson was absorbed with a salary of 3,000 rands per month. Later in 2012, he became Ms. Ne's executive driver. His salary was increased to 15,000, and when the complaint was lodged, he was earning around 16,000. Mr. Dennison was reappointed as the General Manager Infrastructure at a salary of 2.4 per annum. Mr. Nganana, the General Manager Partnership, his salary was increased from 760,000 to 1.1 per annum during March 2013 to December 2014. The other one, Ms. Davis, was appointed as a General Manager Fleet at a salary of 1.3 per annum. In addition to this, there were allegations by Samu that Ms. Nye removed all black employees and replaced them with Indian employees. Those were the allegations, and further alleged that Ms. Davis was promoted to the level of Chief Operation Officer without completing her probation as General Manager Fleet. During 2014, Mr. Dennison resigned from Pikitup after he was charged for misconduct for theft of Pikitup cell phones, which he unofficially issued to Ms. Nye and her family members. In June 2015, Ms. Nye and Dennison were allegedly arrested by SAPS and for stealing those cellular telephones, and were detained. Pikitup paid her bail and paid for her legal representation. It was alleged that there's no disciplinary action which was taken against Ms. Ne. All consultants appointed by Ms. Ne were allegedly not appointed through a proper supply chain management process and were allegedly loaded on the subsystem as Pikitup employees. The consultants were receiving benefits like normal employees and were further provided with tools of trade at the expense of Pikitup. And Pikitup was alleged to have irregularly procured office buildings to accommodate Pikitup head office. Following this investigation, that Pikitup improperly awarded and subsequently extended the contracts for the supply, operations, maintenance, equipment to the designated landfill, garden sites, waste management depot, as well as ad hoc rentals to Aqua, despite the findings of Ernst & Young, Goboto Forensic and Investigative Accounting and National Treasury investigations. That investigation, we found that it substantiated the allegations that the appointment of Ms. Davis was irregular, was founded, it was substantiated. The appointment of Mr. Boysen, Mr. Dennison, Mr. Ngwenya, Mr. Nganana, Mr. Mukele, Mr. Simpson, Mr. Kras, Ms. Alexander, all of them were irregular and improper, and that investigation, we found that it's substantiated. So I found that Ms. Nia regularly removed, the allegation that she regularly removed employees from critical positions or black employees and replaced with Indian employees, that was not substantiated. I found that Pikitup improperly failed to investigate the alleged theft of Pikitup cell phones, and that resulted in the arrest of Ms. Nair and Mr. Dennison, and they never even, they paid bail and even their legal representation. That investigation or the finding was that it was substantiated, and that Pikitup failed to adhere to its own cellular telephone policy, which covers all employees of Pikitup on a fixed term contract, and the appointment of consultants, that finding also was substantiated, and they failed to take any disciplinary action against Ms. Nair and Mr. Dennison. So the appointment of the consultant, as I said, it's substantiated. The evidence revealed that Pikitup did not comply with the municipal supply chain management regulations in the appointment of the consultants and the payment of the consultants, and they've also violated their supply chain management policy, and also violated the Constitution. They violated the internal policies of Pikitup. The findings are that the board of Pikitup should ensure that disciplinary steps are taken against the officials who were together with Ms. Nair and who are still with Pikitup, and further ensure that disciplinary steps are taken against the implicated officials who also flouted their recruitment and selection policy, who are still within Pikitup, and within 60 days ensure that all the contracts with the service providers or consultants irregularly procured are cancelled, and further pick it up to make sure that all those employees and former employees who are implicated in this report, who have committed financial misconduct, they should open a criminal case, and Pikitup should institute a civil litigation to claim in line with Section 176 of the Municipal Finance Management Act to recover unauthorized, irregular, fruitless and wasteful expenditure by Ms. Nair in their personal capacity for all the financial misconduct identified. Then the next reports relate to the plight of whistleblowers. As Pikitup case demonstrates, the demon of poor governance continue to ravage our society unabated, causing untold harm to the public resources, and it goes along. We continue to see the manifestations in the private sector too, the VBS Mutual Bank saga, aspects of which we are investigating, especially the municipalities who deposited the monies in contrary to the MFMA. The saddest part is that the reality is that the poor remain the hardest hit by this scourge, irrespective of whether the thieving occurs in the public or private sector. One of the most potent weapons in the pushback against this cancerous practice is whistleblowing. It is the cornerstone of the fight against this malady. Unfortunately, Blowing the whistle on the wrongdoings brings with a lot of personal sacrifice and risks for those who dare to do the right thing and lift the lead on wrongdoing wherever it occurs. The truth be told, the country does not do enough to acknowledge the efforts of those who blow the whistle on corruption. We have in the past years also investigated several other whistleblower related investigations in terms of the Protected Disclosure Act. So the report which I've issued in August relates to my investigation into allegations of undue delay, gross negligence, improper conduct and maladministration by the Minister of Police and the South African Police Services in failing to provide Umzimkhulu local municipalities whistleblowers, Mr. Tabang Zulu and Les Tuta with security protection. This was an investigation within an investigation because we're still proceeding with the investigation of the public funds which were looted in the dilapidated or in the renovation of the Umzimkhulu Memorial Hall. It has been alleged that a councillor of the municipality, the late Cindy Somakaka, had been killed after having exposed these allegations of corruption. So as part of my investigation, I interviewed Mr. Zulu and Mr. Studa, and they further then later complained about their safety and the threats over their lives. So in this particular instance, I approached the Minister of State Security Agency and the Minister of Police to protect these whistleblowers. And the report in my findings is that the Minister of Police failed to provide the two whistleblowers with protection. I directed, among other things, that the President reprimands the Minister and takes steps to ensure that this does not recur. As you may be aware, the Minister disagrees with these findings and has taken the matter on judicial review. But then taking the matter on judicial review does not stop the implementation of the report unless the remedial action are set aside by a court, or then I am interdicted in that particular instance. So of course the Minister is entitled to this legal action he has taken, and the remedial action anyway will remain binding. The second matter relates to Universal Service and Access Agency of South Africa, USASA, where the board obstructed my investigation when a complaint was lodged by the Chief Executive Officer, Mr. Lungo Mtinde, who lodged the complaint under the Protected Disclosure Act and had alleged maladministration and improper conduct on the part of the board in respect of the appointment of the company secretary and a myriad other corporate governance issues. He had also alleged that the board corruptly and irregularly interfered after he set out to stem and what is so as unlawful and irregular processes as part of the digital migration project, in particular the procurement process for the production, manufacturing and distribution of set-top boxes. The board intended to take disciplinary steps against him. The complaint was lodged under the Protected Disclosure Act, and on receipt of the complaint, I notified the board that Mr. Mtinde had made a protected disclosure in good faith and requested the board to hold disciplinary inquiry. In fact, not to hold disciplinary inquiry, to keep that in abeyance until such time I finalize the matter. But the board defiantly forged ahead with the inquiry and subsequently suspended the CEO following my investigation, which confirmed the allegations of obstructing me from investigation of Mr. Mtinde's complaint. I directed, among other things, that his suspension should be lifted within 7 days of the report. Today, I release yet another report which puts a spotlight the plight of the whistleblowers, which is Mr. Tuso Bloom by the Greater Taung local municipality in the northwest, resulting in his unfair suspension and subsequent dismissal. He lodged a complaint in 2015. Mr. Bloom was a senior administration officer of the municipality and alleged that the former municipal manager, Mr. Mkhwebane, unlawfully and improperly suspended and dismissed him following his making of a protected disclosure to the mayor, Councillor Mkhwebane, regarding that he considered to be irregular procurement activities. So my investigation revealed that indeed the municipality improperly suspended and later dismissed Mr. Bloom in retaliation against his protected disclosure regarding suspected corruption, conflict of interest, maladministration, and related procurement irregularities by Mr. Mkhwebane. I found that this action amounted to occupational detriment as envisaged in the Protected Disclosure Act. So my finding I further found that as a result of this, Mr. Bloom suffered immense financial, emotional, and social prejudice. In the main, he enjoyed the loss of remuneration over the past 5 years and 8 months, financial expenses relating to fighting his intended discharge and dismissal, and among other things, I directed that Mr. Bloom be reinstated within 30 days from date of this report and be paid all his remunerations which have accrued over the previous years. And I implore decision makers across the public administration to take note of this and reports and other reports I've referred to in order to protect whistleblowers. We will be able to fight the scourge of corruption and maladministration. And I commend also people like Mr. Zulu, Studam, Tinde, and Bloom, who dared to raise their hands and also deal with this matter. I now turn to the issues involving the executive members of this country. There was a complaint against Minister Zulu. I investigated allegations of a possible violation of the executive members' ethics code, and this complaint was lodged by a DA Shadow Minister of the Department of Small Business and Development. This complaint was lodged in March 2018 regarding ministerial vehicles for the department. This complainant alleged that Ms. Zulu willfully misled Parliament or misrepresented information to Parliament in her oral reply to questions posed by her in the National Assembly on 29 November 2017 relating to new cars that were procured or were in the process of being procured for Ms. Zulu, the minister and the deputy minister by the department. The transcription of the proceedings of the National Assembly held on that particular day received from the complainant reveals that the complainant put it to Ms. Zulu that the Department of Small Business Development had bought a Mercedes-Benz E400 valued to the value of 1.1 million for her, and a Lexus GS350 valued at 900,000 for her deputy, and a BMW 5 Series for 1 million, all three cars valued at 3.1 million. The complainant questioned the justification for the purchase of these vehicles and the exorbitant expenditure by the department, especially the current challenges faced by the small business in South Africa. In response to the question, Ms. Zulu indicated that she does not drive a Lexus, which was valued, in fact, she's driving a Lexus valued at 580,000. She stated that she did not have a BMW bought by the government. Ms. Zulu also pointed out that the deputy minister drove a car which was inherited from the Department of Trade and Industry. Information received through investigation of the matter revealed that Ms. Zulu responded to the statement regarding the vehicles in Parliament. Her response was based on the current vehicles being utilized by her and the Deputy Minister, and the only vehicles within her knowledge and possession at the date. According to Ms. Zulu, when a budget is approved in Parliament, the document is not immediately available to the Minister, but is published on the National Treasury's website to be accessed by the Department CFO and Accounting Officer. The document is then routed via submissions to the Minister's office. Ms. Zulu further indicated that at the time of a reply to the complainant on 29 November 2017, she was not privy to the full adjusted estimate document and was therefore not aware of the shifting of funds from goods and services to machinery and equipment, authorizing and approving the purchase of motor vehicles for her and the Deputy Minister. She further stated that she was not aware that the cars were being purchased for herself and the Deputy Minister, nor the intent of the department to purchase same. Ms. Zulu made written submissions to Parliament on 15 March 2018, which was a true reflection of the actual transaction, which was a purchase on 20 December 2017 of a BMW 540 for her, valued at 874, and the BMW 540 for the Deputy Minister, valued at 944. According to Ms. Zulu, both vehicles worth 1.8 million, which was far less than the 3 million that was budgeted for. The two vehicles were purchased in December 2017 after the written approval of the expenditure was obtained via the accounting officer. The BMWs were purchased in terms of the National Treasury Transversal Agreement for BMW and Mercedes-Benz, and further in accordance with National Treasury's Transversal Contract. The vehicles were planned to be purchased were abandoned because of the cost of the Mercedes-Benz E400, and the BMW X5 was also abandoned because of the price difference. The Lexus was not bought because it was not contained in the list of the budgeted vehicles. Ms. Zulu justified the need for new vehicles for her and the Deputy Minister based on paragraph 1.2.3 of Chapter 5 of the Ministerial Handbook, where departments are authorized to purchase two official vehicles for each minister, for the Minister and Deputy Minister directly from manufacturers or dealerships when the current vehicle has reached 120,000 kilometers or is older than 5 years. Based on the response from the Minister, a finding could not be made that Ms. Zulu willfully misled Parliament, nor that she prevented Parliament in exercising its oversight function over the department in terms of Section 7A of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act, as alleged by the complainant. No merits could be found to the allegations, and a closure report has been submitted to the complainant and the respondent and the president in terms of the Section 182 1B and Section 8.1 of the Public Protector and Section 3 of the Executive Members Ethics Act 1998. A complaint which was lodged against former Minister Nkosinathi Nhleko. I investigated the complaint. Again, it was relating to the violation of the Executive Members Ethics Act. He was the Minister of Police then, and the complaint was lodged by Mr. Mbele, also from DA, who alleged that former Minister Nhleko improperly awarded a contract worth 30 million to an NGO by the name of Indoni, which is run by his partner, Dr. Mthembu, without going out on an open tender. In doing so, alleged Mr. Mbele that the former minister acted contrary to the Executive Members Ethics Code, specifically paragraphs 2.3 D, E, and F, as well as paragraph 3.1c. The former minister approached the public protector on 29 November also 2016, requesting an investigation into allegations reported in an article by City Press dated 27 November 2016, alleging that he was involved in the payment of millions of rands in favor of Indoni, an NGO. He stated that he alleged the report in the newspaper damning, misleading, malicious, and suggest that he is implicated in the unlawful instruction to enrich his partner. During the investigation, it came to my attention that the Civilian Secretariat of Police Services had lodged a complaint with the Public Service Commission to investigate the alleged irregularity in the process being followed by CSPS in awarding the contract of 30 million to Indomie. The Public Service Commission investigation inter alia made the following findings: that there was no contract worth 30 million that was entered into between CSPS and Indomie as alleged in the media, that based on documents provided to Public Service Commission by CSPS, in fact a total of 1.2 million was paid to Indomie, that payments made by CSPS fails to comply with National Treasury's practice by failing to invite competitive bids in the procurement process and also failed to record the reasons for the deviation of the normal procurement processes. Consequently, the Public Service Commission made the following recommendations: that CSPS must ensure that when it conducts procurement processes, must always adhere to supply chain management policies, that it must ensure that when a deviation from normal procurement processes, it ensures that the reasons for the deviation from inviting competitive bids are recorded and approved by the accounting officer. There was no further recommendation. So the allegation that former Minister Nhleko improperly awarded a contract worth 30 million to an NGO named Indomie, which is run by his partner, Dr. Mthembu, without going out on tender and doing so in violation of the Executive Members Ethics Act, could not be substantiated by the evidence and the information obtained during the investigation. At the time the MOU with Indomie was signed, former Minister Nhleko was not yet appointed as Minister of Police, and he was also not involved in the administrative processes leading to the utilization of the services of Indomie and the subsequent payment to the said service provider. The MOU had been signed on 23 May 2014 between the former Minister of Police, Mr. Mtetwa, and the Civilian Secretariat of Police Services. The final report which I'm issuing relates to an investigation which was lodged by the member of DA, Mr. Steenhuisen, against Minister Gigaba for violating of the Executive Ethics Code and the Executive Members Ethics Act. Mr. Steenhuisen attached to his complaint a judgment delivered by the Gauteng Division of the High Court on 14 December 2017 in the matter of Fireblade Aviation versus Minister of Home Affairs. In terms of the judgment, Judge Tupton held inter alia that there is no escaping the conclusion that the minister has deliberately told untruth under oath by telling a deliberate untruth of facts central to the decision of this case. The minister has committed a breach of the Constitution so serious that I could characterize it as a violation. In this regard, it is the contention of Mr. Steenhuisen that Minister Gigaba not only lied under oath, but also acted in breach of his constitutional duties and the Executive Ethics Code. Following my investigation, I sent Minister Gigaba a Section 9 notice to afford him an opportunity to respond to the provisional findings. I gave him 10 days from date of the notice within which to respond. Unfortunately, there was no response which was received accordingly. And let me also stress the point that in this matter, I was not investigating issues that had been before court, because in terms of Section 182(3) of the Constitution, I cannot investigate court decisions. Accordingly, my focus was on whether or not the minister's conduct as found by the court was consistent with the relevant provisions of the Executive Members Ethics Code. I found that the allegation that the Mr. Gigaba violated the Constitution and the Executive Members Ethics Code when he told untruth under oath was substantiated. As a member of the Executive, telling an untruth under oath or before a court of law is a direct violation of Section 165(4) of the Constitution and paragraph 2.3b of the Executive Ethics Code, as well as paragraph 4.1.3 and 4.1.4 of the Parliament Code of Ethics. By breaching the above provisions of the Executive Ethics Code and Parliament Code of Ethics, Minister Gigaba violated Section 96 of the Constitution, which states that members of the Cabinet and Deputy Ministers must act in accordance with the Code of Ethics prescribed by national legislation. The Minister's aforesaid conduct is in violation of the Code, which requires members of Parliament to act on all occasions, especially the ministers, the executives, the MECs, the premiers, in accordance with public trust placed in them, discharge their obligations in terms of the Constitution to Parliament and the public at large. In addition to the findings, I also make the following observations. National key points are strategic installations as regulated by the National Key Points Act 102 of 1980, such as international airports, military bases, which requires special security. Therefore, any person employed at such national key point may be vetted under the National Strategic Intelligence Act 39 of 1994. The executive needs to consider processes which should be followed and the level of approvals for utilization of national key points by private companies. I now turn to the remedial action and I direct as follows. The President must take appropriate disciplinary action against Minister Gigaba for violating the Constitution, the Executive Ethics Code, and the Code of Ethical Conduct and Disclosure of Members' Interest for Assembly and Permanent Council members. The President must, in terms of Section 35A of the Executive Members' Ethics Act, within a reasonable time but not later than 14 days after receiving this report, submit a copy thereof and any comments thereto, with the report on any action to be taken in this regard to the National Assembly. The Speaker of the National Assembly must, within 14 days of receipt of this report from the President, refer Minister Gigaba's violation of the Code of Ethical Conduct and Disclosure of Members' Interest for Assembly and Permanent Council members to the Joint Committee on Ethics and Members' Interest for consideration in terms of the provisions of paragraph 10 of Parliament Code of Ethics. The President must advise the Public Protector of action taken by the President within 20 days of the date of this report. And the Speaker of the National Assembly must, within 30 days of publication of this report, provide the Public Protector with the implementation plan on steps to be taken against the Minister for breaching the code. Thank you for listening.
Thank you, Public Protector. Colleagues, we are now going to open the floor for questions. Any questions that you might want to pose to the panel in relation to all of the issues that came out in the statement that the Public Protector just read out to the House. I don't see any hands. Mr. Bateman from Eyewitness News is the first one. Is there anybody else who wants to pose a question to the panel? Okay, in that case, then let's go with Barry.
Good afternoon, Vrede panel. Barry Bateman, Eyewitness News. It's just an investigation update I'd like from you, please. It relates to the matter I reported on about a year ago related to former Minister of Sport, Fikile Mbalula, and his trip to Dubai, and a complaint was lodged. I checked with OPA several months ago. He said that you were to the stage of the 7-9 forms being submitted to the implicated parties. If you can just give me an update on where we sit with that investigation, please. Thank you.
Any more questions from the floor? Okay, over here.
It's from ENCA. I'm just trying to figure out, so of course we know that you are investigating the VBS matter. We're obviously quite interested in that one. I know that you've just started with this investigation. Are you able to maybe give us some sort of like aspects of it? Where exactly will you be investigating, and how far-reaching will your investigation be? Thanks.
Tandamayako from Power FM News. I'd just like a status update on the internal investigation into the qualifications of Tshwane officials.
Thank you. Any more questions from the floor? Okay. The PP, you may respond.
Thank you, Barry. Yes, I'm aware that you've been following up with the office several times on this matter. I think you would appreciate that this complaint was lodged, and it was lodged also under the Executive Members Ethics Act. And remember that Act requires us to finalize the report within 30 days. If not, we need to inform the President that we won't be able to finalize within 30 days. So when the Minister was then reshuffled, and he even resigned as a Member of Parliament, then that investigation was then investigated in terms of the Public Protector Act. And I must indicate that, yes, we've promised that that report will be issued soon. But I want to indicate that the Section 7.9, yes, it has been finalized, but we've got processes internally to make sure that there's quality and all the aspects of the investigations are covered. I must indicate that we will have another media briefing end of November. So that report, I think I put it on record that it will be part of those reports end of November. ELCA, the VBS matter, I indicated that the Public Protector doesn't have jurisdiction over private companies, and that investigation relates to the conduct, improper conduct by members of the municipal administration, and the violation of the Municipal Finance Management Act. So our focus will be on the violation of the members of the Municipal Finance Management Act, and as well the steps they followed to deposit the money. Because, I mean, we know that the municipalities receives the grants, and those grants are meant for service delivery. And, I mean, as Public Protector, we intervene because we receive 80% to 90% of our complaints are service failure complaints. And again, several of those municipalities, out of the 16, several of them, we have a number of complaints. So that will be the focus of our investigation, and I must indicate that since it relates to various provinces, Northwest, Limpopo, Gauteng, then and I think one in Mpumalanga, that will be investigated from head office. We've got a provincial investigation integration branch, so that we can have that investigation from one place. So we are hoping that we will not take long to investigate, though that forms part of our investigations, which we say they take up to from 12 to 24 months. But I think we will make sure that we investigate that matter as quickly as possible. But I can't promise when we're going to be able to finalize. From Power FM, the Tshwane officials' qualifications matter, I must indicate that we've advanced so much that we have interviewed all the complainants from Tshwane, interviewed the executive mayor, interviewed the speaker, interviewed some members of the chief whip, I think from the other political parties, especially on the appointment of the chief of staff and the spokesperson and the other officials, and as well the appointment of the current municipal manager. And I must indicate that one I wouldn't also say, I wouldn't promise that it will be it will be with the next reports which we will be issuing end of November. But then the investigation is at an advanced stage, I must indicate, because the remaining part is that we need to then close the investigation and then go ahead with the analysis of the information before we can issue the report. Thank you.
Thank you, Public Protector. Are there any more questions? I've noted the lady there at the back, the first one, and then I'll go here in front, in that order.
Hi, Advocate. I'm Claudia Melovich from Business Day. You have directed the President to take appropriate action. Can you just give us some more details as to what would be appropriate action? Would a letter be appropriate or yes? Yes, the President is. Thank you so much.
In relation to what? She hasn't what report is she referring to? Sorry. Which one is she referring to?
Sorry, on the Gigaba matter, yes. Thank you.
My name is Mwaku Mujaji from City Press newspaper. I just want to find out, I understand that you are also investigating allegations of maladministration, tender irregularities at the Department of Justice and Constitutional Development. I just want to find out how far is your investigation. Thank you.
Any more questions? No? Okay.
Thank you. From Business Day, the President, we cannot prescribe to the President what action he needs to take. That is within his prerogative, because remember, members of the of Cabinet are appointed by the President, and we cannot prescribe. As far as City Trust is concerned, the tender irregularities within the Department of Justice, I think you are referring to the Bulukwane, the Limpopo High Court, or the
complaint which was lodged by the CFF.
Yes, that one. We are at the information gathering stage. We have brought the matter to the attention of the department. Normally when we investigate, we will have to write an initial letter to the department and request all the necessary documents, the tender, advertisement, all documents, bid adjudication, bid evaluation documents, so that we can analyze and determine the issues to investigate. So I must indicate that that is still a very new investigation, and is one of those investigations which falls within the conduct failure investigations, and they will take from 12 to 24 months as well to investigate.
Thank you, Public Protector.
Are there any more questions from the floor? I don't see any hands. Let me check with the panelists if they have anything more to say.
Do you want to say anything?
Okay, it doesn't seem like the panel also has any, the public protector wants to say something.
Yeah, maybe I need to indicate that because after issuing the reports, we'll receive a lot of complaints from our existing complainants wanting to know when are we issuing their reports. I mean, Barry has asked about that one, Power FM asked. So there's an Alexandra construction matter. We've sent the Section 79 to the Gauteng provincial government. Their due date of response was 26th of October, so we have not yet received a response, and I think we will go ahead and prepare a report as far as that matter is concerned. There is a matter of taxi panel vans conversions. I must indicate that one also, that we've completed the investigation. We are now working with the Department of Transport and the taxi industry to come up with remedial actions which will be covering all the affected parties. Thank you.
I just wanted to add maybe that Free State website, you may want to, that's also coming. Yeah, but just another point I just want to make is that Pikitup report should really be required reading for state officials all over the place on how not to do it. It's terrible. Just please go to our website and look at these reports, because it's not just
just to end with the media briefing, they should go and dig into the report and see what actual violations are and what actually happened. And that's the point that I just want to make. Thanks.
Thank you, Public Protector and Deputy Public Protector. I think at this point now I will adjourn the briefing. Thank you so much for coming through.
Thanks.